plebiscite is, should the law be changed to allow same-sex couples to marry? In the event the plebiscite were to be passed, then I would introduce legislation to give effect to the will of the people to amend the Marriage Act shortly thereafter. In legislating for a plebiscite, the government is giving effect to a commitment made during the election campaign and endorsed by the Australian people. The one person now standing between the Australian people and their right to have their say, their voice heard in what would be, on any view, a very, very significant social change is Bill Shorten. So I call on Bill Shorten to get out of the way, to allow the plebiscite bill passage through the Senate, to allow the Australian people to have their say, and importantly, in the event that there is a yes vote in the plebiscite, to allow there to be marriage equality in Australia by early next year. That is now the only clear path for Australians to have marriage equality very soon. If Mr Shorten could stop playing politics with the lives of gay people and put the interests of a cause he claims to believe in first, then he would support the plebiscite bill. We would expect that he would campaign for a yes vote in the plebiscite, and were there to be a yes vote in the plebiscite, we would expect the Labor Party to join with the government in passing amendments to the Marriage Act. Now, in preparing the submission that was taken to Cabinet last night, I have been joined or collaborated with my colleague Scott Ryan, the Special Minister of State, who is responsible for the design features and the mechanics of the plebiscite. And I'll ask him to say a few words about that and about other issues. But what we have striven to do, and I believe we have achieved, is to ensure that there is a completely fair process, a completely neutral question, not loaded in one way or another to favour one side or another, so that the Australian people can make their choice, can make their decision, and if they decide to change the definition of marriage by allowing same-sex couples to marry, I have complete confidence that the Parliament will respect the wishes of the people. Scott.
Thank you, George. In terms of the mechanics of the proposed plebiscite, we have sought to replicate the provisions in the Referendum Act and the Electoral Act as far as possible, so they are familiar to most voters. It will be a compulsory attendance ballot with normal access to pre-poll voting, postal voting and declaration voting. The result of the ballot will be determined by a simple majority of formal votes cast, as is the case at a referendum. So the majority will be determined by those with valid votes yes, as opposed to those with valid votes for no. There will be the requirement for authorisation of materials, as is normal in the Electoral Act, and we will be seeking to include that to apply to what I might call new communications mechanisms such as robocalls and SMS messaging. There will be a yes and no advertising committee established. This is based again on precedent, having looked back at the experience of the 1999 Republic referendum. There will be $7.5 million provided to each yes and no committee. There will be 10 members of those committees. There will be 5 members of Parliament, 2 provided by the government, 1 from the crossbench and 2 by the opposition. The other 5 members will be, or those members and the other 5 members will be appointed by the Attorney General and myself, as was the case in 1999. In 1999, the budgets for the yes and no advertising committees had to be approved by the then Ministerial Committee on Government Communications, whose parallel now is the Service Delivery and Coordination Committee of Cabinet. That process will be adopted again, as will clearance of the materials and advertising. Deductible gift recipient status will be provided to these official yes and no committees, so they can take tax deductible donations. The tax deduction will be capped at $1,500, which is again the same that applies to political parties in the Electoral Act. So as you can see, we have sought to replicate existing practice and process as much as possible.
Can I just clarify, so there are 2 committees of 10, is it?
2 committees of 10, a national yes committee and a national no committee. And as I said, there will be 5 members of parliament. There will be a chair appointed from amongst the 2 government members, and there will be 5 non-parliamentarians, and the Attorney-General and I will seek public submissions for membership, and we will appoint those, as was the case in 1999 with the Republic referendum. In that case, of course, we had the Constitutional Convention to draw from, and there's no similar parallel now, but we have adopted the process as far as possible.
Have you sought any advice or re-examined whether a plebiscite could be held without legislation? That is, in the event that the legislation does not gain support of the Senate, could you hold a plebiscite, for example, a non-compulsory plebiscite without legislation, and is that an option to consider to fulfil your election promise?
The commitment and policy is for a plebiscite conducted in line with practice for referenda, and that would be a compulsory attendance ballot with all the provisions that the AEC can operate, including things like the 6-metre exclusion rule around polling places, requirement for authorisation of materials, and compulsory attendance at a polling place or access through a postal vote or declaration vote. That's the government's policy, and that's what we're putting to Parliament and asking Bill Shorten to consider and allow the Australian people to have their say.
But doesn't you kind of just establishes a level playing field, but religious organisations are already DGRs. It's been already donated to them tax-free. Doesn't what you're proposing actually just maintain an unlevel playing field?
No, not at all, because we've treated both sides exactly the same here. There is tax deductibility in line with the contribution to a political party, capped at $1,500 of a tax deduction. There will, of course, I would imagine, be supportive and opposing committees established outside the official national yes and no committees, and they are free, of course, to run their own particular campaigns, as long as they comply with the Act. I should have mentioned, sorry, one thing I did omit. We are applying a 3-day blackout period, as is common at elections, for electronic advertising, but that is not something in the Referendum Act. We are seeking to apply that in this bill.
The result of a referendum is immediately binding. Will the result of the plebiscite be binding?
I'll let the leader in the government address that.
Paul, what will happen in the event there is a yes vote is that I will introduce amendments to the Marriage Act to give effect to that outcome virtually at once, as soon as the result is clear. And as I said in my remarks, I have no doubt whatsoever that in the event of a yes vote, the Parliament will respect the wishes of the people. There are many of my colleagues who I know who have said both privately and publicly that they would vote no in the plebiscite, but in the event the plebiscite were to carry, they would vote yes on the floor of the Parliament. So the question, the suggestion, I should say, that the plebiscite is not a useful vehicle because it doesn't bind the Parliament is a false issue. There is no doubt whatsoever that if the Australian people choose to vote yes, the Parliament, both sides of Parliament, will respect their wishes.
And what information will be available from the plebiscite? Will it be electorate by electorate, booth by booth, state by state? How will you gauge whether a majority view has been formed on the issue?
So the vote will be determined, the result will be determined by a simple national tally of formal votes yes versus formal votes no. Informal votes are always excluded in referenda in determining the result, in that case by state and by the national result. In this case, the result will be determined by a simple national tally of formal yes and no votes. However, as is normal practice for a referendum, the results will be reported through the AEC by polling place, division and state, as well as a national tally.
What is your message to coalition moderates who have argued against public funding for both the yes and no campaigns? Did you put the argument against public funding for both campaigns in discussions last night, as I've been told that you did? And thirdly, Dean Smith is now saying he will not vote for the plebiscite in the Senate.
James, what you need to know is that the government has arrived at a position with which everyone, or virtually everyone, is comfortable with. There's no secret that there was a variety of views leading up to this process. But we had a very good and long discussion in Cabinet last night, a very good and respectful discussion in the party room this morning, and the government is united behind this process. Not everybody got everything they wanted, but the where we have landed is something that is acceptable to everyone.
How can you be comfortable with the process, though, if the result is that Labor will block the plebiscite in part because of...
Well, this is a test for Mr Shorten. This is a test for Mr Shorten, because Mr Shorten now has to decide whether he will say to the Australian people, I don't trust you to make this judgment. I'm not interested in what you have to say about this question. And if, by the way, like me, you'll be voting yes in the plebiscite and would like to see marriage equality, it is Mr Shorten who stands in the way of that too. It is Mr Shorten who is saying to gay Australians, you can just wait while I play politics.
Just on a process, the Referendum Act, doesn't it provide that if one House passes legislation twice, then the Governor-General can issue the writs? If that's to happen in the House, would you just proceed without taking it through to the Senate?
Well, that's not the way. Senator Ryan can speak about the specific provisions, but the plebiscite mechanism will incorporate from the Referendum Machinery Provisions Act those provisions concerning the conduct of the poll and so on that are appropriate. But there is no question at all, as Senator Ryan has said, that the definition of success in this plebiscite is 50% plus one of the national tally of formal votes.
Haven't you agreed with that?
Sorry, Scott.
Yeah, I might just say that provision is in section 128 of the Constitution. It acts solely with referenda. This is a bill for a plebiscite. We have adopted the Referendum Machinery Acts and the Electoral Act provisions to provide a familiar voting experience and to ensure that it is a fair process, one which all citizens and all advocates are familiar with. So in this case, we are asking, and it does require legislation through the Senate for the plebiscite to take place in the form that we have proposed, and we are asking Bill Shorten to follow up on when he said a few years ago that he was open to the idea of a plebiscite and let the Australian people have their say on this important issue.
Standards of the advertising has to meet. What control will you have over the content?
So if I could read to you, I'll read to you now the provisions from 1999 which we intend to apply. The budget was made available for research, including polling and market testing for the purposes of the advertising campaign, planning of the advertising campaign strategy, concept design, creative work, writing and production of the advertisements and media placements through the Commonwealth's Media Placement Agency. Proposed advertisements at that time are to be cleared by the then Ministerial Committee on Government Communications. MCGC, now the Service Delivery and Coordination Committee of Cabinet, will ensure proposed advertisements do not infringe appropriate standards.
Senator Ryan, do those rules apply to all advertising in a plebiscite or only to the advertising that's run by the sort of official yes and no campaigns that have the tax deductibility status?
Well, we don't have the power to necessarily legislate for this, or we don't have the existing regulatory power over standards for groups that are not funded by the Commonwealth or receiving DGR status as these are. That is a matter for the television networks.
Will anti-discrimination laws be suspended for the referendum?
No, they won't be.
Senator Brandis, you said that you wanted this to be as close to a referendum as possible. Why not then just legislate changes to the Marriage Act and make them conditional on a plebiscite passing to make it self-executing? Why do you need to bring it back for a parliamentary vote? And secondly...
Well, sorry, can I deal with that question first? There are two reasons. First of all, the whole point of this is for Parliament to be informed by the views of the Australian people. So the plebiscite would naturally come first. On the alternative model, the parliamentary vote would come first. But secondly, there are serious concerns about the constitutionality of a self-executing plebiscite. The Constitution provides for only one mechanism for changing the law by public vote, and that, of course, is under Section 128 for amending the Constitution itself. Otherwise, our Constitution provides for a very specific three-stage process for amending the law. Passage of a bill through the House of Representatives and the Senate, or vice versa, and assent by the Governor-General. By introducing what would in effect be a fourth stage, there is serious reason to believe that it might be, were we to approach it in that manner, susceptible to constitutional challenge.
Haven't you allowed essentially this plebiscite to be self-executing in the way that perhaps the word doesn't originally mean? In allowing Conservatives to get public funding, you have given them the one thing that will mean Labor and the Greens can't vote for it. Isn't this just a plebiscite now that is impossible to gain in Parliament?
Well, I'm not responsible for whatever political games Bill Shorten might choose to play, but the process that we've established, the architecture of this plebiscite, is completely even-handed. Everybody is entitled to precisely the same funding, precisely the same tax concessional treatment when it comes to DGR status. The question is fair and even-handed. This is a completely level playing field with both the proponents and the opponents of change playing by precisely the same rules.
Senator, I'm not entirely clear just from what Ryan's answered before. In the event that this plebiscite legislation does not clear the Parliament, as looks pretty like a safe bet, Scott said it's not your policy to mount an alternative non-compulsory plebiscite, but that doesn't rule out doing it. So
well,
you rule out
Catherine, let me make it very clear. This is the way in which the government proposes to deal with this issue. That's what we took to the election. We were re-elected. That position was endorsed. All the public opinion poll evidence shows that there is a clear majority of the Australian people who favour this matter being dealt with in the way that the government proposes to deal with it. And the ball is now in Mr Shorten's court because, as I said before, he is the one person who now stands between the Australian people and their right to have the say that they want to have on this important social question. And he is also the one person who stands between gay Australians and their capacity to be admitted to the institution of marriage, which is something I strongly favour. Now, you must excuse us now because Senator Ryan and I have to get to question time. Thank you.
Yes, so abruptly winding that media conference up because their own Senate question time is looming at 2 o'clock for George Brandis and for Scott Ryan, the Special Minister of State.